Good evening and welcome to the Law Chamber, where legal matters are discussed from a Christian perspective. I'm smiling but I'm down. See how saying? 3-2. Hi. Okay, so we are not that happy, but we still have life goes on. Oh, say any Korea share near Shomo maybe a 2-0. Oh, ne Jeme. Yeah, started your calculations in that. But we still have to learn. So today's topic is quite simple. We're going to talk about when there's no will. So last week we discussed when there's a will. When you make a will, how to make a will, when to make a will, who the beneficiaries will be, everything about it. We discussed it last week. So today, let's say today you have made up your mind that you're not going to make a will, irrespective of what we said last week. You still have made up your mind that you're not going to make a will, or that you might be a beneficiary under the Intestacy Act. And what is it? We're going to discuss that this particular evening. And before we move on, let me say a very hearty welcome birthday to my producer extraordinaire, Dinah Ajapoku. Because behind her back we call her Shorty. A short. Dinah, Majwa, happy birthday. And it's my prayer, say, all your dreams that you have, now, as you are growing up to be a very beautiful young lady, you become one of the icons of the church. Amen? Yeah. All right, so, still, Pella Fest, Pella Fest, we are going for the Pella Fest. And the Pella Fest, as we've already told you, is coming off on the 31st of December. If you are going alone, it's 70. If you want VIP, it's 150. And if you're a family of 5, you are looking at 300 Ghana cedis. Right. So please get your ticket in your various churches, or just call the number on your screen, and then we'll just get you your copy. So today we are going to discuss inheritance when there's no will. Inheritance when there's no will. So I have with me 2 guests, a gentleman and a lady. So let me start with the lady. So I have with me lawyer Mensima Adjoa Crenstel. I always say that it didn't like Crenstel. Crenstel. Hey, Crenstel. Yeah, she's a barrister and solicitor, meaning she's a lawyer. She's a state attorney. If you don't know what a state attorney is, please, I beg, Google. She's a state attorney. She's also a lecturer at Central University College Law Faculty. So the law faculty at Central University College. She's a lecturer there. She has an LLM in criminology and criminal justice. Criminal law, on the day she said she has a specialty there. And when it comes to inheritance, we are hoping that she will give us a very nice and interesting discussion for today. Adjoa Mensima.
Yes.
You're welcome.
Thank you very much.
I hope you will.
I'm well.
Everything is fine.
Everything is fine.
You are going to break everything down for us.
I hope so.
I hope you are not too sad.
No,
you're not a football fanatic.
No, I am. I am when Ghana is playing. But, well, what can I do? Like you said, life goes on, so.
But we have to start doing the calculations. Meet Korea, then we score this one. Then I have with me lawyer Godfrey Enim Nyako. He's also a lawyer, of course, barrister solicitor. He's an associate at Yao & Co. Efisem Chambers. He's a trustee and executive committee member of the Diamond Field Ghana Conference SDA Church. He fellowships with Agape. Agape and I Debisa. Pokwase SDA Church. Godfrey, you're welcome.
Thank you very much. Thank you very much.
You're welcome.
It's been a long time.
It's been a while.
Yes, you have to be inviting me.
I have to because I'm surprised this is the first time you are coming to this show.
Yes, since every time you meet, we fight. So I thought that wouldn't be.
You want to tell the whole world that you are fighting buddies.
But then today we are on a good thing.
So today is going to be a good one.
It's going to be a good
Okay. So let's. So when we talk about intestacy, what does it mean? Ajamenzo, when we talk about intestacy, what comes to mind?
Okay, so basically, like the topic for today is, intestacy is when you die without making a will. So that means that all the things that you left behind, you didn't give any instructions as to who it should be given to, who it should go to, and it's just open. The things are just there and there's no will. So basically, there's no will. That's basically what intestacy is.
And what are some of the laws that govern intestacy and who is an intestate? Can you?
Okay, so like we said, an interstate person is somebody who died interstate. So that means that you died without making a will.
So intestacy is the word and the person is intestate.
Yes, the interstate person, yes.
Okay. All right. And what are some of the laws that we'll be looking at in respect to intestacy?
Oh, talking about mainly the Interstate Succession Law, 1985. That's the PNDC Law 111. So that's the main law that governs a person who dies interstate. Yes.
Okay. So PND. So if you forget anything at all, please don't forget PNDC Law 111. That's what we are going to discuss today. PNDC Law.
Yes.
111. So someone dies without making a will. Go for it.
Yes.
How are we looking at it? So let's start with, how will the properties be shared?
Yes, so let's first look at what the PNDC Law 111 came to cure or rectify.
Okay.
In fact, we know we have the account system, where when somebody dies, then the family members, the customary family, would move into the house and then push the wife and the children out of the house, because we know that per custom is the nephew who survives the deceased person. So the first government decided to pass an act to rectify this problem, because this is a situation where the family has struggled to make properties. Well, when the head of the family dies, then the customary family comes to take over from the properties. So it's meant to cure that problem, to ensure that the surviving spouse, in this case maybe the woman who has survived the deceased husband, and the children benefit from the spoils of the husband. So Interstate Law 111 came to cure that problem. When somebody dies intestate, as she said, it's basically somebody who has died without making a will. Or if the person had made a will before he died, maybe he did not put in a general clause, residual clause, to take care of.
What is the residual clause?
When you make a will, you make specific provisions in a will. Maybe my house located at Asamankese, I give it to my husband or my wife, or I give it to this person. But then you can make all these specific provisions in a will. But then at the time you were making the will, you didn't know that you acquire other properties after you had made the will. So you put in a clause that any other property I acquire after making this will, I give it to this person. But if you don't put in that clause is what's called residual clause. It's supposed to save the will of other properties that are made before the will. If you don't put in the clause and then you die, then PNDC Law 1 will govern properties that does not, or is not covered by the will.
So it's possible for you to make a will, but then because you didn't update the will, or you didn't make that clause,
yes,
that will cover future properties or properties you are not aware of,
yes,
those properties
will still be governed by PNDC Law 1.
Okay, so it will be treated as if you didn't make a will, just for those properties.
Yes, so although you died testate, you died making a will, but then certain properties will be governed by PNDC Law 111. So that is what basically intestacy is all about.
So what properties are we looking at here? So if you die without making a will, what are the properties we are looking at under PNDC Law 111?
Oh, so we are looking at houses, we are looking at cars, we are looking at chattels, anything that has value of any sort. We are looking at all these, everything that you had as property, anything that the person acquired in their lifetime, anything that they were given, anything that they have ownership over, all of those things, we are looking at them under the law.
So it means properties that you own.
You own, you have ownership.
So if it's not yours,
no,
it's not part
if you don't own it, if for example you are given authority over it. So for example, you're a chief of a community, you have lands. You can't say that those lands are owned by you personally. And so you can't give those things in a will. Okay, things that you are taken care of for the family. Maybe you are the family head and there are certain properties that are given to you to be the custodian over during your lifetime. You can't will those things, and those things don't also fall into intestacy. So if you die intestate, those things can go to the beneficiaries who otherwise would have benefited from your properties. Yes.
Okay. So it means that we are looking at a law that says that you didn't make a will. You have properties. We are now going to share the properties according to law.
That's so.
So the law is now, you don't have control over who will get what. The law is now going to determine who will get what.
Yes.
So Godfred, who are the law looking at when they want to share your property when you make a will?
So the law has distinguished between the properties. It has first set aside household chattels. Let's say the TV you die possessed, the clothes and other personal things used in the house. So the law has created beneficiaries for their properties. We start by saying the surviving spouse.
Okay.
When I say surviving spouse, either your husband or the wife, the person who survives the deceased person, the surviving spouse. Then the children, the housekeepers for the children. A child-in-law means either you were born in the marriage or out of marriage, you're a child. So whether your parents got married before giving birth to you or not, you're a child. The law caters for you. Then the parents, the law also caters for the surviving parents of the disease, and then the family in general. So the law does not take away the importance of the family from the distribution. But then these are the four categories that the law takes care of.
So if you don't make a will, the law is saying that we are going to divide your properties, and we are going to look at these four people.
Yes.
The surviving spouse, that's the husband or the wife.
That's right.
It can be wives. We'll come there.
Yes.
It can be husband, but we are looking at wives.
Yeah. Yes.
Then we are looking at the children.
Yes.
Then we are looking at the parents of the person who is dead. And then we are looking at the customary successor.
Yeah.
Okay. So let's say someone dies without making a will.
Okay.
And we are looking at these four group of people or these four persons. How is the law going to divide the properties?
Okay. So, like we said, these are the people, like Godfred has said, these are the people that the law caters for. The law is saying that for the surviving spouse, they get 3/16 of what you leave. Now, the children or the child is getting 9/16, and then the parents are getting 2/16, and then the customary, those who fall under the customary law or the customary successor is getting also 2/16 of everything. So basically what it says is that everything that you have is going to be divided into 16
after
as
taking
it were,
out.
yes, 16 equal parts, and then it's going to be divided amongst the people that the law considers as beneficiaries of your estate.
But generally we'll be taking out some of the things for the children
For
and
the
the
children. Yes, so the law makes a particular provision that when you die survived by just one property. In fact, the law has categorized certain properties as matrimonial properties.
Yeah.
When the person dies, the house that you are occupying with the surviving spouse, that becomes a matrimonial property. So when the person dies just with one house, that house goes to the surviving spouse and the children. The family has no interest in it. The parents have no interest in it. So the law specifically gives it to the children. Other properties can be shared according to the law. That's it.
Okay, so let me try and break it down. So what we are saying is that you die, you didn't make a will.
Yes.
We are looking at four group of people. We are looking at the spouse, we are looking at the children, we are looking at your parents, and then we are looking at the customary successor. Okay, so when you die, the first thing we do is one of the houses, the matrimonial home generally, but we give preference if you have more than one house. They can pick any of the houses that they want.
Yes.
So, but if it is
Apart
just
from the matrimonial house.
but if it is just one house, it goes to the wife
and the
and children,
Yeah.
or wives and children, and the children too. We are not just looking at the children within marriage.
Yeah.
So if your husband has gone to sleep around and has slept with lots of women and they all have children,
outside
all those
wedlock, yeah.
will come and share in the house.
Yeah.
Yes.
And then the second one is chattels.
Chattels.
The
Yes,
chattels,
the
so it
household
means the
chattels.
household chattel, which sometimes include a car,
Yes.
unless the car is for commercial use.
that's it.
But if it's not for commercial use,
It's
it's
part of the
it's
chattels,
part of the chattels.
That's
It goes
right.
to them. And then the rest of the property, we bring it together.
And
Then
we
we'll
share it.
divide it into 16.
Yes.
Then the 3 will go to the surviving spouse. Then 9 will go to the children.
A child or children.
Or children. 2 will go to the parents. If they are. So let's look at it. So it means if the parents are dead.
If the parents are dead, the portion that's supposed to go to the parents will go to the customary successor. It doesn't state expressly that customary successor, but it says that
Yes.
it should be shared in accordance with customary law.
Okay.
So if per the custom of your area, it is shared amongst the head of families, that's the way to be shared. So that's the special provision the law makes. So the children, the spouse, the parents, but if the parents are not there, then it goes to customary law.
So it means that if one group of people, that person doesn't exist, so let's say there's no spouse, it will be shared on it. So it's still this group of people, no one comes in.
Nobody comes in.
So let's say, for example, the person doesn't have anyone, the person doesn't have surviving spouse, no children, no parents, there's no custom that really governs this person's life. How are we going to share the property?
In that instance, in fact, the government takes over.
Yeah.
So in that instance, the government takes over, and then if anybody was depending on the deceased person at the time the person died, that person can apply to get a share of the property. But then we know that when the person dies without a spouse, a child, parent, or customary law or successor, then the government takes over.
So let me try to...
When you die in a forest somewhere and nobody knows your whereabouts, your property goes to the government, basically that.
So if you are not married or you don't have a spouse, if you are a wife or husband, you don't have a child or children, your parents are no more, your customary successor, who may be your customer, it means that your property will go to the state.
That is so.
In Ghana will take over your property. So the question I ask myself is, why are people refusing to make a will?
In fact,
That's how it's going to be shared when you don't make a will. If you are fine with it, will. But if you're not fine with it, this is the time to make your will. Godfrey, you want to say something?
I said, in fact, the sad thing is that it's rather professionals who refuse to make wills. Those who know what is right to be done. In fact, making a will doesn't mean that you are going to die tomorrow. Whether you make a will or not,
you will die
will die
eventually.
So it's better that you prepare and you decide who should take your property than to leave it for the state to determine who takes over the property. That's it. So that's the main advantage in making a will. And we advise people to also make wills because it's less expensive. You can do a will yourself, so long as you comply with the provisions of the law.
And last week we discussed wills. So I know that we know a lot of these things. So let's say the person is dead, right? Mm-hmm. And the person didn't make a will. Mm-hmm. And I'm a child or I'm a spouse. What am I supposed to do? We are looking at letters of administration and all. What's the procedure?
Okay, so then you have to apply to the courts. You have to apply to the courts and then state that this is the situation, the person is deceased. You have to prove to the courts that the person is indeed dead. You have to show that you are related to the person and that you have the right to even take the letters of administration. So you apply to the courts and then you add all the properties that you know. You see, that's the disadvantage of dying interstate. Even the person going for letters of administration may not know all the properties that the deceased has. But as much as you know, you add that, and then also if you can show that they are the owners of it, and then apply to the courts so that the courts can do the distribution according to the law.
So right now, if someone has died, either your parent or your spouse or the person dies, you can formally go to court for an early letters of administration. We call it early.
Yes.
That will give you the power to distribute the property. So, Godfrey, if such a person doesn't go to court for the early and the person is dead and they start distributing the properties, what happens?
Yes, so in fact, it is against the law. You offend against the law, and we call it intermeddling, which you can be jailed for. Yeah. But then I'll support what my sister said. When, in fact, we may not know whether you made a will or not when you die. So what, on the practical side, what you do is that you do a search. You just write a letter to the nearest court where the person lived before the person died to do a search whether the person died or not. So you write the full name and address of the person and do a search. the search shows that the person did not make a will, then you, the beneficiary, if I say beneficiary, I'm talking about the surviving spouse, the child, or the parent, you can apply for latest menstruation. You can either see a lawyer to apply for you, or you do it yourself. It's not a difficult thing. It's that you have to swear affidavit indicating a lot of things, including the last place of abode. You add the evidence of death, either the death certificate or medical cause of death, or even the funeral brochure. You can add the funeral brochure or even a poster to indicate that the person had died. And the court will give you the authority to administer the estate. But if you don't do that and you start sharing the property without the knowledge of the law, then in fact the courts can punish you for that, to the extent of sending you to prison for that. So we encourage people that you don't take the law into your hands and start sharing property, but then you go through the process of the law to get early data administration before you manage the estate of a deceased person.
Okay, so let's say, for example, it's the men who die early. So let me use that example.
In fact, we admit.
Oh my goodness.
Let's say the man is dead, and all his property is not even up to 800 Ghana cedis. Are you saying that we are really going to share it among these four group of people?
Yes, in that sense, the law has stated clearly that where the property does not exceed a certain value, but the Attorney General is by law supposed to increase the figure. Now it's 1,000 cedis. Then it goes automatically to the surviving spouse and the children. In this sense, the parents do not have a share in it, and then the family does not have a share in it. If the person does not also have a surviving spouse and child or children, then the parents will take over the property, which is less than 1,000 cedis. So as the practical side, when you are applying for LA, you do what you call inventory. You state all the properties you think the person died survived with, and then you state estimated value. So the estimated value is what you pay 3% estate duty on. So if the total value does not exceed 1,000 cedis, then automatically the property goes to the surviving spouse and the children.
Okay. So I want us to break it down. I want us to break it down a bit. So the person died, they make a will. You've gone to search in the courts to be sure that the person indeed didn't make a will. The court writes back and tells you that the person really didn't make a will. So you get your lawyer, you have your LA done, you go to court, and then you list all the properties you think the person has. Then you pay to the court 3% of the whole estate value, because the state needs money.
Yes,
so that's
it's
tax. So you pay 3% on it, and then now you can share the property according to these four group of people. So you take the one house out, you take the chattels, if there's a house, you take chattels out. If it's just one house, it's still you take the children and the spouse will take. You take all the chattels out, and then the rest will put it in 16. We'll divide it 16 equal parts. The spouse will take 3, the children will take 9, then parents will take 2, and the customary successor will take 2. So we've done all that. Now we have the house. You have a house, still it's in your father's name or it's in your husband's name. What process should you go through to be sure that it's now yours? Because you can't sell it. So what do you do?
So yes, in fact, the person who died may have even registered the property of the Lands Commission. So if you want to sell it, you can't, because the person's name is the Lands Commission. There's a process the law asks you to go through. It's called vesting assent. In fact, it's very simple to do. It's just a one-page document. So per the process of doing a vesting assent, it means that automatically you are vesting the property in the beneficiary. After you've done the distribution, you prepare a vesting assent, and that authorizes you to sell the property or even transfer it to anybody that you want to. But without getting the vesting assent, you don't have authority to deal with the property or sell the property. You
stay in the house for as long as you want, transfer. But you can't sell it.
Yes, you don't have ownership of it.
That happens a lot, because people don't go for lawyers before doing this thing. So they think the mere fact that they've shared, you can use the property for 20 years. But then when it becomes necessary to transfer or sell the property, then you have a problem, because you can't without doing the vesting assent.
So the situation where the man and the woman are in their matrimonial home, and let's say the woman dies and the woman's family come and sacks the man and the children, that is unlawful.
Yes, that's unlawful. In fact, it's a criminal offense. If the family does not have any right to sack the surviving spouse and the children from the house when the man dies. In fact, we are all presuming that the man or man dies before women. In a situation where the family or the man and the woman and the children were living a family property before the man died, the law says that you cannot evict them within a period of 6 months after the man dies. So you give them ample opportunity to look for a place to live in. So within a period of 6 months, if you evict the person or you forcibly eject the person from the house, it's a criminal offense which is punishable by law.
Wow.
Yes.
But it's happening.
It's happening a lot. We experience a lot of these things. And then the women go around and because they don't know their rights.
That's right.
It's difficult to enforce it. This law has not been explained very well to this extent. So a lot of family members are abusing spouses, surviving spouses and children. Even this modern time, you have educated people who are still doing a lot of these things, painful things against surviving spouse. It's happening.
Can a grandchild inherit under PNDC law 111?
Yes, a grandchild could inherit under certain circumstances. So ordinarily, from what we've discussed, we see that grandchildren are not part of the beneficiaries when it comes to intestacy. But where the deceased has his parents are not alive at the time that he dies, then the property can go to the grandchildren if they can show that at the time that the deceased was alive, he or she was the one who was taking care of them. Yes, so they have an interest in the estate. Yes.
You want to add something to it?
Yes, so what the grandchild has to prove is that at the time the deceased person was alive, the grandchild was depending on the deceased person. So in this situation, the grandchild has lost the father. The father was supposed to benefit from the grandfather. So since the grandfather died, the father cannot benefit because he is also dead. But then the father died before the grandfather. So the grandson was dependent on the grandfather. So in that situation, then the law says that since you were dependent on the grandfather before he died, then you're entitled to the share that your father would have been entitled to.
That's right.
Yeah.
So someone is listening to us right now and all she's thinking about it. My spouse died about 7 years ago. And the properties, they didn't get an early. They sacked me from their house. Is it still possible to get these properties back? Because I can see these properties around. Is it still possible to get these properties? Is it?
According to law, it is. According to the law, you have 12 years within which you can apply for these letters of administration. It's just that, like we've discussed, sometimes within the 12 years, so many things would have happened. So, I mean, the sooner, under these circumstances, the sooner the better, because people can deal with these properties even before you get to know about it and all that. So, if it's 7 years, they've taken you from the matrimonial home. In fact, you can even have an action against the people who treated you that way because it's against the law, clearly. Yes, and then you can also get compensation from the law. But yes, if it's 7 years and it's not past the 12 years, it's still within time. And you can still get the letters of administration and still get your what is due you under the law as a beneficiary.
Okay, so let me try and summarize it in 3 quickly. Tiniaka so far and I say, I just say we are will. Well, ne say o sure be because say me wu am pese weni di made. But so why wadwen say wonye ana wonye ya ye wo mre bi wo hono ma mbra ne be chen yen se ne enje wu japade so don kan che say yenche wu japade si nti mbra ne be chen say yenche wu japade ni si nti mbra ne say nkofo 4 bi ne be wu japade ne be cha ma omo oyiri ana okunu nipa na uja no oyiri ana okunu a uja no no umba umami ana umami ne papa so mu ya life ina wankasa o custom ufi baby ne bai and obi ti asantini ana egbeni ana fantini bibia ufi ba no ye wo se na eje ijapade into the 4th one no sane ommechen sisa ebeko mo hono into wo hwe mu pa na edan ne ba ko a edan ba ko no ene nyema na nipa na wewu no yusu ye no ni nia beko oba na no be ma na aka ene nkola ne ho nti ba me fa ne say wo dan 5 a nipa na wugya no ho no ono mba no ombefa dan ne baako na nyema na ebia o car o shoe wa tire we dua ade a wo dididi bibia na efe ne personal chattels ni nia beko oyere ne mba no ana okunu ne mba no na aka no ye de ba together ni a chemu into 16 ye chemu into 16 na 3 ebeko oyere ana okunu no ho 9 beko mba ho 2 ebeko o maame ana papa ho na 2 no o custom se na ye che no akọ no inti se wanya will na opese ye che oja opese emra che oja pade a opompo sa na emra ne be che oja pade ni ye kan kola so a enye se akola baby awa nipa wa ware no na wo ware no ne nkola pe na ye nkola da bi inti baby a wawo bia no sa nkola ni aye nkola inti da bia ya usually ye catch especially in ba no say do baby obeka say me na me yere o mba na aka no mo nya yere a mo nya yere nti ye chijapade na o mo nya bi o ba se nkola ne part no o mo ye ne so ne nkrofo na wo o mo ye ne mba so mba beje o mo di efim dan ba ko na ye o de na e de ama wo ne nkola no mo so ka ho nti wo ti fie ho won ga samba so ti fie ho na ne mba na wa wo mo ni awa bonti ni ano o mo se ba betena fie ho bi because omo ka ho bi na so bi wu na wanya will sana dey obey first na so be court na wa kwa search na wa make sure say nipa na anya will the second one no be LA if it be LA letters for administration and the mema otumi no answer what to change apade no ebi mo ha nipa no wu ye na wa asase change apade no eye ade so yes sana e for intermediate criminal offense wetin me akodem for 1 year. Nti wo say do baby obi wu ana busuafo aba no ma pame nkrofo na fio wo isa nkrofo na mo pame ye ko report wo betimi akoda prison for 1 year nti hwe ne yie ese boko court nti sa nipa 3 way either na yere na na nikru no sam ne nkola na parents obeko court na court no ama ne document e che say ejapade no ne de sisi amuti meche tini a che ne se ne ye kan maka no ye che ne sa pepepe na fe de was akọ court because ejapade ne bi o ho enu din mu nti betime tena fie ho because e yaw de but land commission na baby a document ne wono e still ukunu ni din na papa din ne also nti je se akọ court ni e baby e fe ne vesting asset no ye de be ma wa ne no che se ya sesa ye change document na fi papa din mu ana ukunu din mu ana yiri din mu aba wo din mu no na obetimi from there no betimi aton sa property in so far no ni are discussing no into sometimes I dey imagine ne say into we ni na no why so why we so on your will we are will betimi say na like can last week ni betimi dey mo bi a ope but so one your will assign crofo we obi wo hono ma obi a o depend on no e bia wo fase ana onua ba a o hwe no into one your will sana no one less na me boy no ni di ni mu bi nsani pa no yentimi nhwe ni bi obi so say me ya will a afi no mbekọ court akoy tieska kesi ama lawyer na nyama ne ya hia nipa kasa ya shikaka cause nyama ne ya hia no still nipa no mbekọ court akoye LA akoye all those documents no ni boye de nka crossing sanka wire will no nti pa che yenhwe ni yie na your ba na unimobi ni apam na finifie ne maame ne papa ewu ni aba pame sa nyama no law no PNDC law wa obi pame we fie o papa fie ana okunu fie na ye fie no so aka say PNDC law 111 say untimi pame me na tena fie hodin o itimi ko report ma police ye betimi taking upon it. And so let me ask this question, let me ask this practical question. It's so easy to force people to try to convince people to make a will. But someone can also decide that, well, I can see how the division is going to be. I know that people that the law says are going to inherit me if I don't make a will, and I'm okay with it. What do you say about that, Benzema? I'm okay with it.
Well, that's also like something you can look at, thinking that, okay, I didn't make a will. So PNDC law is going to give it to my spouse or my spouses, my children, my parents, you know, customary successor. But why don't you just make a will and make things clear? Okay, so for example, when we talk about dividing what we call the residue is when you take the house out and then you take the household chattels out, which you give to the spouse and the children. You have certain property left. Now they're going to divide it 3, like we said, 9, 2, 2. And sometimes these properties, they are not properties that can be easily divided. For example, let's say you have 2 extra houses, okay, or you have land somewhere. Sometimes dividing all of this is just complicated. Bringing it all together. One practical way you can do that is to decide that, you know what, if we can't agree on this, let's just sell everything. Whatever we get, we're going to divide it. But if you sit down and make a will, you have, let's say, 2 extra houses. You can decide that, okay, I have 4 children. I'm giving maybe these 2 children this house in East Legon. I'm giving these other 2 children the house in wherever. It makes it simpler. It makes it clearer. It reduces misunderstanding and quarreling after you're gone. Because you see, as much as the law tries as much as possible to curb some of these things after somebody is gone and they didn't make a will, it's not always airtight. It is always easier, it is always clear when you just make the will and things are just simple on the surface. Everybody can read it in black and white. So yes, I think that it's always better. It's always better if you actually go ahead and make a will. Even though, I mean, there's also the option of not making the will.
We said a lot. Yes. Let's go for this short commercial break. We'll be right back.
Every day the world gets a little bit harder now.
For one night only, the city will converge at the National Theatre as United in Praise presents the A Cappella Festival. Yes! Brace for a divine musical experience on Saturday, December 31, as Ghana's hottest a cappella groups usher us into 2023 in a grand style. On stage performing Black Capella, The Manifest, Vocal Path, Note 6, K3M, New Era, Soul Street, and many more. Special appearances by Pesdak Praise Choir, Gifted Dia, Mark Enimirenchi, and Perez Music. Get an early bird tickets now at a cool 70 Ghana Cedis standard for single, 150 Ghana Cedis VIP, and 300 Ghana Cedis for a family of 5. Simply dial *928 *529 hash to get your tickets now. The A Cappella Festival is proudly endorsed by Beyond the Return and supported by Charterhouse, Events Dome, Midima Foheba Clinic, Meridian Ghana Conference, and powered by United in Praise. Pella Fest, a Hope Channel Ghana production.
Have you heard the exciting news? United in Praise presents Pella Fest, the A Cappella Festival, playing live at the National Theatre, 31st December 2022. The gate opens at 5 p.m. It's going to be a night to remember, a night of prayer and praise. Hope Channel is giving an opportunity to 2 young a cappella groups to rub shoulders on the big stage. If you believe you deserve to be on the stage, record your a cappella group in performance and send it to hopetvghana@gmail.com. Together with our viewers, we will select 2 groups to perform with the Manifest, Soul Street, Vocal Path, K3M, Black Capella, No 6, New Era, and many more. The A Cappella Festival, live at the National Theatre, 31st December 2022. Dial *929 *529 hash now to grab your ticket. For 70 Ghana Cedis single, 150 Ghana for VIP, 300 Ghana Cedis for a family of 5. A Cappella Festival, a night to remember.
come back and let's take these few questions. Erica Yamwa has a question for us. She says, in situations when the estate value is overstated, hence the 3% LA is overpaid, can there be a refund? If yes, how? If no, why? Ajamensma.
That's a very interesting
It
question.
is.
Yeah, very interesting question. If it's overstated, so first of all, if it's overstated, it's not the fault of the law, or it's not the fault of the state. And practically, in the sense or in the spirit of fairness, we should say that, it should be able to be refunded. But in practical terms, it might not be so easy to get a refund. I don't know about any situation where that has actually happened, but with these things, that becomes rather difficult. So what I would say, or that I would advise, is that be sure of what you are stating. I wouldn't say understate, because then I would say...
But that's what most people do now. They actually understate.
But under the circumstances, that would be a safer bet, so that if later you have to do a top-up, it will be easier. But to overstate and then ask for a refund, I don't know how practical that may be. I don't know if Godfred has like a contrary view.
But
yes.
I think it's possible.
Yeah.
Because we always go and vary the estate value.
Yeah.
Normally, the variation that I've done most of the time is to rather vary to increase the value of the estate.
Yeah.
Because
That's
when you reduce the
safer.
value, the total amount that you put there, when you go to the person's bank account and the value in the account is more than the total amount, you have to come back to the court to vary to increase so that you pay the requisite estate duty. So in the situation where you think the value that you stated on the application is more than in actual sense, then you have to support with fact. In that sense, I suggest that you do a valuation of the property, get a valuer's report, then you can file a motion to vary the estate value. In that sense, I think the court can make an order to reduce the estate
Yes.
value, but then getting the
Your money
difference,
back,
with
that is
you have
the-
to go through the system.
Charlie,
Yeah.
the money
You have
goes
to go
into
to
the
the
state coffers.
Exactly.
when
So
you
then
Getting
the
it
court will
back.
say we should pay you.
Yeah.
But the
But
state
that is-
But then
indeed
you
pay
have to be writing letters upon letters to your court manager.
Yeah, the
to get it.
practicality of
It's
it.
quite difficult.
And I like the bit you brought about the bank account, because ordinarily when someone dies, the bank will not tell you how much the person has in the account. So you don't know. So when you are writing, you write, let's say, GCB, unknown.
No, yeah.
So when you total everything and the total amount is, let's say, 5,000, and you go into the bank account and the bank account has 10,000, the bank will not give you the money, although you have an early. The bank will not give you the money because the total amount on your document is less. So you have to go back to court for you to increase the amount and make it at least 10,000, and then you pay the 3% on the 10,000 for the banks. I don't know why the banks do that.
Let me give you a practical example.
Yes.
There was one that I did. Let's say the value of the bank was 10,000, and then the estate total amount was 5,000. So I went back to the court to increase the value to 10,000. By the time we finished the court process and went back to the bank, interest had added upon it to 13,000.
Wow.
So I had to go back to the court.
So you have to
Three
just
times.
keep going back and forth.
So because when you get an early, it takes time.
Wow.
Yeah.
Posting for 21 days and other things. So by the time you realize 2 months has elapsed, you go back to the court, the interest is piling up. So normally we rather advise that you increase the total amount to exceed the money at the bank so that you don't go through
And most
this
of them, you
hassle.
don't know the amount in the bank because the banks will not tell you.
So you have to do
Find
your
a
checks.
way.
Here in Ghana, you have a lot of
You
ways
really
of
want
doing it. I can't say it on air. But then you have to find
Yeah.
ways
a way of getting.
the value there. Otherwise,
Yeah.
you have problems. You have to go back to the court
Back
for
and
the
forth.
money to
Back
be
and back.
reviewed.
So tell us about the 21 days and the LAs, how it goes through. Give us the
Yes, so
short
let me, the
process.
practical sense, either you see a lawyer or do yourself, you file a motion for letters of administration. Ordinarily, the surviving spouse, if the person is alive, the children and the family will nominate another person to become administrators. Normally, it's preferred that you choose more than one administrator so that the person will not monopolize the thing. So the spouse
will not chop your money.
will not chop your money. So the spouse, one of the children will represent the children, and then the family representative. You apply to the court. There are things that you provide. First, you provide evidence of death, either death certificate, medical cause of death, burial permit, even the funeral brochure or the poster to let the court know the person has died. Then there are other documents that you swear oath to, the oath of administrator, and then the statute declaration. You sign all those documents. The statute declaration is where you indicate the inventory. It indicates the properties that, to your best estimation, the person died possess. And then you put estimated value. When the person has a property in East Legon, you don't put 5,000 cedis there. Because the court reasonably know how much East Legon property costs, although what you put there is estimated value. My lawyers try to go around it by saying that the property is uncompleted house. Meanwhile, it's a mansion the person is living in it, just to reduce the estate value. So after calculating the inventory, the total amount that you put there, you pay 3% as stamp estate duties to the state. So when you go to the court prefers that all the applicants will be in court before the application is granted. If the applicants are not in court, the court will not grant the application. If any of the applicants are outside the country, they have to give power of attorney to somebody to represent them in Ghana. When the court grants the application, the court would make an order that they post notices. You call it notice of next of kin at the last place of abode of the person. So where the person dies, the last place of abode, they will post the notice of next of kin.
The last place the person lived.
Yeah, the last place the person lived before the person died. That's the last place of abode. They will impose the notice of next of kin there for 21 days. In certain instances, the court can reduce it to 14 days, depending on how best the lawyer is able to convince the judge to reduce the number of days. But ordinarily, it's 21 days. So when they put the notice for 21 days, after 21 days, you, the applicants, will go back to the court. You have to go and sign documents. You go to the court with a valid ID. You go there with 3 passport pictures, and then you go with a witness each. So if the applicants are 3, you go with 3 witnesses each. You go and sign the court documents, and then you pay the estate duty before the LA is issued to you. So it's not a long process, but then you have to go through this process.
It takes so far. These all things been equal within a month, 2?
Yes, so after the 21 days, within a week or 2, because then the court will have to type the necessary documents. And the court process sometimes takes time. So let's say within a month or maximum 2 months, you should be able to go to.
So we have situations where, yes, these 3 people are supposed to be represented, have reps there, but they are fighting. So the family rep, they want the property to themselves. They don't want the children. Can one of them go to court for the court to give that power to him or her?
Yes, currently I'm doing a case in court. I can't mention any, but then the surviving spouse has problems with the family. So what happened is that when the surviving spouse was willing to go and apply for LA, the family was not willing to cooperate because the family took upon themselves some of the properties of the man. So the spouse went to court. What we did is that we deposed in the affidavit that because of the problem in the family is not willing to cooperate with the wife to apply for the LA. So based on that, the court granted the LA. But then the unfortunate situation we had is that the family turned around and filed a suit in court to challenge that LA. So it's still pending in court because they want to revoke the LA that was granted. So, but then if there's a problem and the family doesn't want to cooperate with you, the affidavit that you swear, you have to let the court know that this is the reason why the family is not cooperating. Because although the law does not make it compulsory for the families to give their consent to LA, most courts require that because the family has interest in the property, the family head or customer successor must also swear affidavit indicating that they have given him the permission to apply for LA.
Yeah. So we have Emmanuel Ajiman. His question is, let's assume that if your grandfather died, leaving his property for your mother without a will, so your grandfather is dead, and he leaves, let's say, a house to your mother without making a will. Can your mother make a will and hand over this property to her children?
Okay, so what this means is that the grandfather is dead, right?
Yeah.
And then he didn't make a will.
Yes.
So
but
that
he gave
means
the
that
property to
he gave it to her. Let's say he gave it to her as in she should live in it.
She should take it.
She should take it, but he didn't make a will. So under PNDC law, what that means is that she is entitled to it, but maybe not exclusively. She's entitled to it with grandfather's spouse, she being a child. I don't know. You see, that's the
So I think
difficulty.
I get him. You know, properties that are gifted by somebody before the person dies is not captured under properties. to
Okay,
be
I say
shared
as
and
a
abused.
gift.
So if from what I understand, maybe the grandfather gives the mother, not through
As
a
a
will,
gift.
but as a through a gift. We have you have customary gift intervivals
Yeah.
and other things. So
Yeah.
if it was they comply with the customary gift intervivals, and the property was given to the mother, if the mother does not vest the property in herself,
So it means that the mother has to do
A
a
vesting
vesting
assets,
asset
yes.
to her
To
name,
her name.
and then she gives it to the children.
To the children.
But if it is,
It's
let's
not
say,
part
also
of the
it's not-
estate.
Yeah.
So that in this case, it
It's a
means that
gift.
it's a gift. So it's
Yes.
not even part of the
Part of
estate
No,
at all.
no.
Yes.
But let's say in this instance, it is part of an estate,
Estate, okay.
where it's been shared.
It's been
and
shared.
Right.
hers is the one she's living in,
Okay.
but there's no will. So
Okay.
it means that she has to go and do an LA,
Yes.
do a vesting
Do a
asset,
vesting.
put it in her name,
So it will be vested
and then she
interest
can
in
will
her.
it.
yeah.
Yes.
So, Ima, your mother has to go through that process so that it will be in her name. So when it's in her name, then she can will it to her
whoever.
children. Daniela Nanaya Smith, please, it's your friend Daniela. Yeah, Daniela, how are you? Assuming both grandma and grandpa own the property, but it's only grandpa's name, and grandpa dies intestate legally, can grandma write the will? So we are looking at a property, grandmother, grandfather.
Yeah.
And most of the time, it's the men whose names are on the document. So the man is
Unfortunately.
dead, unfortunately. The man is dead now. Can the woman will this property?
In fact, I would say the woman can will her share in the property.
Okay.
The challenge we have in the court is that the court is still battling with the fact whether or not a property acquired during marriage is for both parties. So I'm doing a lot of these cases that the woman will then apply to the court and say that she has an equal share in the estate. There's one that we're even doing a trial. What happened was that the man had children before marrying this woman. He never had any child with the woman. The man dies. They had one big estate. Then the children filed a lawsuit in court saying that although our father married you, we don't know you. So you don't have any interest in the property because we think our father won a lottery and used the entire lottery amount to buy the house. You did not contribute anything for the house. And they want to prove to the court that their father used that lottery amount to buy the property. So they want to prove that that property is not a matrimonial property. Although the woman, they stayed true before the man died. And I'm representing this old woman. The woman is 83 years old.
Wow.
So the challenge we have is that although we admit the man won a lottery, used the lottery to buy the property, but the woman contributed in building the house. The man was living outside the country. The woman was the one in Ghana supervising the construction of the house.
Then
So
you
that's
have
so
a
all
good
that we are
case.
saying that the woman has an interest in the property, although the man is the one who uses his money to purchase the property. So in mostly matrimonial issues, although the woman may not have contributed financially, but the woman has interest in the property. So the woman can will her interest in the property to somebody.
Okay. Okay. But let's look at this also from this angle of so it means that the grandfather died without making a will. So
Yes.
apart from her interest, if she can go for an LA, she also has an interest in the man's share.
So the reliefs I'm asking for in counterclaim was that you are asking for a share of an equal share of the house because she contributed.
Yes.
Yeah.
And then we want a share of the remaining half because
She's
of
a spouse.
PNC law 111.
Yeah.
Come on, that would be a good one. Where did he?
Oh, the case is still in
I
court.
hope you are following. I know it's a little bit technical.
Yeah.
I know it's a little bit technical, but I do really hope you are following. So I have another question. Actually, I have a lot of questions here, but I will try as much as possible because we have a few minutes left. Let's see. I think I had them. Okay. If you will a property that you acquired secretly, no family member knows of that property, and you die, can't the lawyer, if greedy, sell the property without letting anyone know of that property or will?
In fact,
Be practical.
that is not possible.
Why not?
Because when you do a will, you deposit a copy in court. It's not your copy that you have in your wardrobe or the lawyer's copy that it is read. It is the court's copy. So when a person dies and you do a search from the court, the registrar of the court will write to all beneficiaries and invite you to the court, come this day. In your presence, they will bring the court's copy, open it up. In fact, they will show it to everybody that the seal is not broken before they open it up. Open it up, they will let everybody write your name and sign that you were present that day. So in your presence, you cannot deny that the seal was broken. Open it up and read it to the hearing of everybody. So the lawyer in his chambers cannot change his copy because it is the court's copy that they use. Even when you apply for LA, what the court does, or when you apply for probate, let me say probate in this particular sense.
Probate is when you've made a will. And then
what the judge does is that they request for the official copy from the registrar to be brought to court for the judge to assess before it's granted. They don't request for the copy from the judge.
But you know that some family members, they trust the lawyer so much that they're not going to apply to the court to do a search or anything. They'll ask, lawyer, your papa your will. They help your papa in your will. Oh. And they say, yeah, papa, and they jump at the end, now oh, it's these 1, 2, 3. And then they take the word of the lawyer and the other properties.
But myself, I've done a lot of wills, but I don't keep to mind the properties that I do for the people.
You don't. So what we are saying is it is possible for the law. That's why we say don't keep secret.
It's not possible.
You see, anything is possible. Anything and everything is possible. Let's don't take anything for chance. Okay, can't a greedy lawyer connive with a family member, change your will when you are dead? It is possible. This one, I have seen it before. A lawyer conniving with a family member, and please, it's possible. But the good news is that, as Godfrey said, because the court has a copy, if you are diligent, all you have to do is do a search in the court, and ask the court for a copy.
Yeah.
You get that copy, you know what is going to who and who is going to who. You understand? So yes, some lawyers can do that, but you can stop them with the procedures we've given so far. Okay, how can you prove that someone was of unsound mind when making a will? For instance, you know your husband doesn't like a particular family member. I will never will anything to him. But when your husband died and the will was read, everything was willed to him. Your instinct tells you he was forced to make the will, or the will was forged. How can you prove that?
Let me give a practical example. I did a will for the man was 87 years old. The man is still. In fact, I've not had any notice that he's dead, so I'm thinking he's still alive. 87 years old. The man has 12 children with 3 wives, but then the will I did, he gave 90% of the properties to one person. And you know what we did? I asked him to give the reason why he has decided not to give anybody any of the properties. Child. Normally, when you don't give reasons in the world, that's where there's always contention. So we started giving reasons why I'm not giving to this person. This person did not take care of me when I was sick. I asked him to buy food for me. He did not buy something for me. He gave reasons for everybody. We listed the names and properties as it's supposed to be. So normally, there's a presumption that when you make a will, you're of sound mind. So the burden will be on the person who is. I'm being a little bit technical, but the burden will be on the person who is challenging.
So he who alleges must prove. So if you are saying someone is on sound mind, you must prove. The question is, how do you prove? Time is up.
So what we do is that normally you prove by indicating the properties. If the person normally states a property that is not real, maybe the person said that I have a property in Silicon, but the person has no property in Silicon. The person lives in Asamakasi somewhere. The person states that my child Kofi Menu, the person has no child called Kofi Menu. Then there's a presumption that the person wasn't of sound mind when he was making the will.
So you use some circumstances.
To determine.
All right, so let's round up. Ajo Mensima, your final words.
Well, final words. I think that we've said it all. Last week we discussed the wills. It's always a good idea to make wills. And what I'll say is that get a lawyer when you're making a will. It's your best bet. Get a lawyer, get the right legal advice. go through the right processes and update your will. I think a lot of people don't do this. They don't update their wills. They make a will maybe 10 years ago, they get more property, more money, and then they don't update it. So update your will, get a lawyer, and make a will and then put everything in there. It will save you, and it will save the people you leave behind when you are gone. It's a really good idea.
So I would say that if you are suffering from abuse from relatives, there are avenues you can go to Scratch or Legal Aid to seek redress. When you don't have money for a lawyer, go to Legal Aid, go to Scratch.
Help you.
They'll help you to seek redress.
Thank you so much. So we've discussed wills. We've discussed when you don't make a will. Next week we are going to look at SNET benefits, and then the tier 2 and then the tier 3. So you've made a will or you've not made a will, but still you've contributed to SNET. You've contributed tier 2, tier 3, even sometimes your office. You have shares. How do we get these properties? And can we change the beneficiaries? What are the processes? We'll have SNET here, we'll have the VRA boss here himself, the head of. We are going to have big people here next week to tell us how pensions, SNETs, and all those ones are shared. And if someone is dead, how you can get those benefits. So join us same time next week. Until then, please stay safe. Good night.